I just wanted to introduce myself quickly. I'm Tamara Herrera, here at the Arizona State University, Sandra Day O'Connor College of Law, probably in the reverse order. And it's my pleasure to introduce you all to our third annual Judy Stinson Lecture Series. For those who don't know, we started this lecture series 2 years ago to honor Judy upon her retirement for many things. You should go to the webpage to read all the things. I won't read all the wonderful things that Judy has done for the community, except for I want to point out to everybody that part of our reasons for wanting to do this is she's such a great mentor to many of us, both with the teaching and the scholarship. And this is a way for us to sort of pay it forward and to pay tribute to all the things that Judy means to us and continues to be involved with. So we thank you. Thank you all for attending. As I said earlier, for those who didn't catch it, there will be time for Q&A at the end, so you can put your questions and answers in the box that you see below on your screen. And I'm going to turn the mic over now to Judy to introduce our speaker for today.
Thanks, Tamara. And thanks to Tamara and Andrew Carter for all their work in putting this year's lecture together. I really appreciate it. And thanks to my legal writing colleagues at ASU for having this lecture. It's a little weird having something named after you when you're still alive. I am still alive, I'm not dead, but I have retired. And so it's somewhat of a transition, but I'm very honored. And so thanks to all of you. And nationally, thank you for the folks who are here and watching. I think it's just so wonderful that we can have opportunities like this to share really great papers and for people to hear each other's ideas and learn something new. Now it's my great pleasure to introduce Professor Christine Venter. Christine is the director of the legal writing program at the Notre Dame Law School. She has a BA and a JD from University of Cape Town, and then LLMs and an JSD from Notre Dame. She likes school, apparently, and I just discovered 3 of her kids are in grad school, so it keeps going. Professor Venter has had performed extensive service in legal writing over the past 2 decades. And I'm really pleased that she agreed to deliver this year's lecture on her paper that was published in the Wake Forest Law Review, Dissenting from the Bench, the Rhetorical and Performative Oral Jurisprudence of Ruth Bader Ginsburg and Antonin Scalia. Professor Venter received the 2021 Teresa G. Phelps Award for this paper. Very well deserved. It's the leading scholarly award in our field, and just so well deserved. I was drawn to Professor Venter's paper because I've always been fascinated by dissents. Any judge or justice who feels strongly enough about the result to spend the time and energy to publicly disagree is, I think, a good thing. And Christine's paper says so, so of course I'm right. I was happy that her paper had that same perspective. But I think it's good for the development of law. It's good for marginalized populations. And we all know yesterday's dissent may become tomorrow's law. And so I think it's really fascinating. I also really enjoyed the rhetorical lens that Professor Venter used in terms of evaluating these oral dissents. And I'm excited for today's lecture. So thank you to Christine for being willing to share this fantastic paper with all of us here today. And with that, please join me in welcoming Professor Christine Venter.
Well, thanks so much, Judy, and thank you for inviting me to speak at the Stinson Lecture. It's a great honor to be selected for a lecture that's named after one of the seminal figures in our field, Judy Stinson. And so I'm thrilled to speak even virtually at an institution that's so supportive of legal writing as a discipline. As many of you are all too aware, legal writing professors have struggled to gain recognition in the academy as serious scholars. And so I'm particularly grateful that ASU Law School sponsors events like this so we can gather as a virtual community to learn from each other. As proof that we do in fact learn from each other, in this talk I cite to 2 of my predecessors in this lecture, Linda Berger and Mel Warish, and I'm grateful to both of them for their work. And I also want to specifically thank Judy Stinson, Tamara Herrera, and Andrew Carter for their help and guidance in preparing for and setting up this lecture, and for putting up with my technological ineptitude. Along with them, I'd like to thank Kim Holst, who kindly hosted a writer's workshop a few years ago at ASU, which I attended when this paper was just a vague idea. Kim, Rebecca Hanley, David Austin, Rosa Kim, and others kindly helped me get this paper out and gave me the support I needed to get beyond the idea stage to writing and actually getting it published. I'm very much reminded the paper only became a reality through the support of our legal writing village and ASU in particular. I'm also extremely grateful to have received the award from the Legal Writing Institute for the paper and would like to thank the Legal Writing Institute for that award and for funding my scholarship. The award's named after Terry Phelps, who's a friend and mentor, as well as being my predecessor here at Notre Dame. I've learned so much from Terry, and I would not be here without her. So let me actually get started and talk to you about the paper itself, which, as Judy mentioned, is called Dissenting from the Bench. I'd like to focus the talk on three specific things. First of all, I want to talk about the paper and the claims that I made there. In doing so, I'll address what I think this paper teaches our students about legal writing and rhetoric, and about legal reasoning in particular. In the second part of my talk, I'd like to talk more specifically about how reading dissents can help our students develop their professional identities as they try to reconcile their personal selves with their newly emerging professional selves. Through reading dissents, I will argue, students find what Linda Berger calls a place to stand in the law by learning that the law is not one monolithic autonomous set of rules. In the third part of the talk, I'd like to briefly address the role of dissent as it relates to the legitimacy of the court and explain why, like Judy, I think the practice of issuing dissents from the bench is an important practice that should continue, especially in our ideologically divided court. So I'd like to start off by summarizing the main points of the paper for those of you who haven't had a chance to read it, and admittedly, it's rather lengthy. The article describes the evolution of the Supreme Court and how the court gradually became more comfortable with the concept of dissent. Originally, the court's practice was to issue decisions seriatim, like the English courts, which involved each judge issuing his own opinion and then summarizing the points on which the justices agreed. The point there was to emphasize areas of agreement among the justices, so the role of dissent was minimized. Occasionally, too, the court would issue an opinion by the Chief Justice on behalf of the court, per curiam, with little to no reasoning attached. Gradually, the practice of issuing opinions per curiam gained ascendancy, as the court, led by Chief Justice Marshall, thought it best to present a united front, given that the US was a relatively new democracy, and it was important that law was regarded as clear, settled, and certain. Dissents were only issued in the most controversial cases where there were serious differences among the justices that could not be smoothed over. It is no surprise, therefore, that the first oral dissents, read in their entirety from the bench, came in the Dred Scott case. These dissents were offered by Justices Curtis and McLean. Interestingly, Curtis's dissent so inspired Abraham Lincoln that he was said to have kept a copy of it in his pocket, showing that dissent can galvanize and inspire responses and resistance. The Dred Scott dissent was not a catalyst that generated multiple oral dissents, as the prevailing sentiment of the time remained that certainty and unanimity were more important than individual justices' ideas about the correct decision. As Justice Brandeis famously wrote as late as the 1920s, it's more important that an applicable rule of law be settled than it be settled right. As the court settled into its role in the 20th and 21st century, dissents became more common. In fact, unsurprisingly, as the court became more ideologically divided, dissents were normalized, and the practice of dissenting orally when the court announced its decisions began to be relatively regular occurrences. Flash forward to the court in more recent times, and the practice of issuing oral dissents, while not common, reached its heyday during the period 2000 to 2020, when Justices Scalia and Ginsburg held sway on the court. These justices were two of the most prominent oral dissenters, who at least once a year read a dissent orally from the bench. In the paper, I described each dissent and examined the kinds of cases in which the dissents were issued. I looked at the language, the tone, the authorities and the sources cited to by the dissenting justices. I chose that period because it was marked by a declining norm of consensus, striking ideological differences, which still are a hallmark of the court today. I argued that the legal reasoning embodied by these dissents delineated the respective justices' view of the law. Justice Scalia regarded the law as an autonomous set of rules that could be derived from the text and the writings of the founding fathers. In his eyes, his view of the law embodied orderliness, and according to him, exhibited the values of objectivity, clarity, logic, and binary judgment. Justice Scalia appears to have subscribed to what has been described as the autopoietic or autonomous approach to law. This view of the law asserts that law's intellectual and systemic development proceeds according to a logical procedure and rationale of its own. In other words, law operates without regard for social conditions and changed circumstances. Adopting an autopoietic view of the law means that one ignores virtually any contextual, social, or political factors in determining the outcome of a case. Decisions made by means of the autopoietic process derive their validity from normative rules, such as the text of the Constitution, statutes, or existing precedent. The judges making the decisions do not generally have recourse to non-legal texts, such as sociological studies. There is a circularity and a certain self-referential structure to an autopoietic view of the law. That methodology, while it may be clear, ignores the lives and experience of the litigants before the court, while purporting to neutrally dispense justice. Yet in so doing, it also ignores the fact that this reasoning and the rhetoric which accompany it often disempowers the already powerless and reinforces the existing distribution of power and wealth. This type of reasoning also involves the disdain for the facts of the case. For example, leading Scalia to deride reporters for, quote, caring too much whether the little old lady won or lost by the Supreme Court. I couldn't care less, Scalia famously said, as long as we get the law right. This self-referential approach is the medium by which the law itself reproduces its normative elements, which privilege certain groups at the expense of others. Unsurprisingly, based on this approach, Justice Scalia chose to orally dissent, often in criminal cases. For example, where the court precluded the death penalty for certain classes of people, such as those who committed crimes while minors or those with intellectual disabilities. Scalia also dissented on important social issues like gay marriage, the constitutionality of the Affordable Care Act, and the treatment of Guantanamo detainees. The ways in which he spoke about the litigants in several of these cases was striking. In Roper versus Simmons, a case involving the death penalty imposed on defendant Simmons for a crime committed while he was a juvenile, Scalia noted in respect of studies submitted by the American Psychological Association to the effect that minors did not have the same moral capacity to reason as adults. Well, at most, these studies conclude, on average or in most cases, persons under 18 are unable to take moral responsibility for their actions. Not one of these studies opines that all individuals under 18 are unable to appreciate the nature of their crimes. Given that psychologists had testified that the defendant, Christopher Simmons, was very immature, very impulsive, very susceptible to being manipulated or influenced, it seems extremely unlikely that Simmons fell into the category of minors who, according to Scalia, could fully appreciate the nature and consequences of their crimes. Moreover, as Justice Kennedy pointed out in the majority opinion, the experts testified about Simmons's background, including a difficult home environment, dramatic changes in behavior, poor school performance in adolescence. Simmons was absent from home for long periods, spending time using alcohol and drugs with other teenagers. Yet somehow these facts did not convince Scalia that 17-year-old Simmons perhaps did not deserve the death penalty. My research also found that Scalia's opinions, while rhetorically clear and renowned for their witty turn of phrase and use of metaphor, were replete with these kinds of disparaging comments about the litigants. He ignored the fact that law can be substantively unfair or tilted towards the interests of the powerful, which undermines or negates the interests of the least powerful, including people of color, the LGBTQI community, women, the poor, and disenfranchised. Although Scalia gained a following for his colorful use of language, there is an important lesson for our students, as James Boyd White urges young lawyers to consider, quote, the humanity and inhumanity in speech, particularly in professional speech. Justice Ginsburg, in contrast, always seemed to recall that the final cause of law is the welfare of society, to quote Justice Cardozo. She reserved her oral dissents for cases involving various forms of discrimination, whether in respect of Title VII, voting rights, or access to reproductive rights. In dissenting, Justice Ginsburg saw herself as an advocate and often relied on the facts of the cases to show the court where it had gone wrong and to urge the court to reconsider the implications of its decisions. Justice Ginsburg was closely attuned to the facts of the cases before her, citing frequently to the record as well as to sociological sources. Her rhetoric was described as transformative. Quote, it shifted the language of the law to legitimate voices, experiences, and rights of groups traditionally excluded by the rhetoric of the law. Even though she was speaking in dissent was a clear indication that her position had not prevailed, nevertheless, even a dissent written from a position of institutional power can provide recognition to a group that feels otherwise unheard and disenfranchised. Justice Ginsburg, I argued, engaged in what Lonnie Guinier described as demisprudence, which occurs when a judicial actor inspires non-judicial actors to participate in some form of collective problem solving, such as the act of Lincoln carrying around Justice Curtis's dissent and later issuing the Emancipation Proclamation. Demisprudence presupposes that the dissent has a ready audience, which will be responsive to and engage with the dissenting opinion. A classic example of this occurred when women, in response to Justice Ginsburg's dissent in the Hobby Lobby case, left copies of the dissent in Hobby Lobby stores, along with copies of the Seneca Falls Address. In her dissents, Ginsburg relied on a variety of sources, including sociological studies, along with the facts of the cases before her, as well as related precedent. Scholars have suggested that when judges rely on sociological sources, their opinions appear to find more favor with the general public than when they rely on purely legal sources. Sociological legitimacy aims directly at public acceptance, and its benefits can be grasped by the public more readily. In using these types of sources, Ginsburg reminded her audience that law exists for people and not the other way around. So what does this paper teach us about legal reasoning? I would argue that it teaches us a great deal. In our profession, legal reasoning is a threshold skill. For those of you not familiar with the concept of threshold skills, in 2003, two economists, Jan Mayer and Ray Land, developed the theory that each discipline has a threshold concept, a concept that once understood changes the way that a person thinks about that discipline or subject. A threshold concept can be considered as akin to a portal, opening up a new and previously inaccessible way of thinking about something. It represents a transformed way of understanding, interpreting, or viewing something, without which the learner cannot progress. As a consequence of comprehending a threshold concept, there's a transformed internal view of subject matter. I should note that I learned about threshold skills from Mel Warish, who gave the Stinson Lecture last year and talked about that very concept. Legal reasoning is such a crucial threshold skill. Thinking like a lawyer involves not only dissecting the legal reasoning that you read in case law, but being able to use legal reasoning yourself to predict an outcome or argue for a result. Yet it's a skill that I watch my students struggle to develop. They are adept at reporting the outcome of a case, describing the facts, but they're not generally insightful when it comes to identifying the reasoning behind a decision. That's important because until they have grasped that concept or way of thinking, they have not really entered the legal profession. Being able to identify and engage in legal reasoning and speak the language of the law is the gateway to effective legal analysis and advocacy. Dissents often lay out the legal reasoning behind the judge's decision far more clearly and in a more impassioned way, especially oral dissents, because the judge is attempting to explain why she feels so strongly about this issue. And in doing so, she explains clearly what the majority got wrong, thus effectively distinguishing her own reasoning from theirs. Oral dissents convey these differences more effectively because we speak in general only about the things that we are passionate about. The fact that Scalia and Ginsburg use different sources as authority enables students to clearly identify reasoning in cases where those justices dissented. Additionally, Ginsburg's approach challenges our notion of the law as being fixed and immutable. Judges who participate in the debate about the meaning of law by oral dissent not only teach our students about reasoning, they also teach our students that the profession is broad enough to encompass all kinds of claims, values, positions, and perspectives. For many students, this is not just important, but crucial. When students look to legal reasoning or the law as it is presented to them, some of our students do not always find it reflects their view of the law as it should be. It doesn't reflect their concept of how the law should work for people. Some students easily relate to and assimilate the dominant discourse of the law, but other students struggle to feel part of the legal profession because often the dominant view of law presented to them is that law primarily serves the needs of the privileged. If law only privileges the past, the status quo, or those who already have privilege, some students will obviously feel alienated. Part of our students' learning process as students is to not only be able to identify and use rules as reasoning, but to become part of the profession and join its discourse community. In doing so, students are socialized into taking on a professional identity. Having a professional identity represents the extent to which students feel like a true member of the profession and a true member of the community of practice they have chosen to enter. Communities of practice are formed by people who engage in the process of collective learning in a shared domain of human endeavor. Identity formation is an ongoing process that organizes experiences and relationships into a meaningful whole, incorporating elements of personal, private, public, and professional life, and providing an overall sense of self. Identity is continuously created and recreated through professional discourse, experience, interactions with others who are members of the same profession, as well as interactions with legal opinions. In forming a professional identity, students need to reconcile their various personal identities with their professional one. Sometimes, for some of our students, that's very hard for them to do, particularly if the law as written does not align with their personal values, ideas, or experience. In order to flourish, our students need to see there are different dissenting views of the law, and there is a place where they can comfortably reconcile their personal and professional identities. Students, whatever their opinions and backgrounds, need to be able to read legal reasoning that accommodates diversity of opinion. They need to be able to imagine change. Many students are looking for a form of legal reasoning that is based on human experience, that is sensitive to middle grounds and in opposition to all or nothing judgments. In teaching legal reasoning, we need to get our students to read dissents as well as majority opinions so they can see that there is a place for dissent in the law. In doing so, we'll challenge and help them form their professional identities and find a place for themselves in the legal profession. As Robert Post has noted, courts do not end democratic debate about the meaning of rights and law. They are participants within that debate. In the final part of this talk, I'd like to briefly address the role of dissent and rhetoric in the current political climate. On one hand, much has been said and written about the court's recent practice of deciding cases on the shadow docket as opposed to the merits docket, often without providing reasons for their ruling and without full briefings and arguments. This practice runs counter to the ideals of full deliberation, consideration, and transparency that are the hallmarks of the rule of law. Many of the decisions made on the shadow document are not attributable to particular justices, and its use has been criticized not only by liberal members of the court, but also by Chief Justice Roberts himself. I would urge the court to revert to the practice of deciding all contentious cases on the merits docket and leave room for oral dissent while they're doing so. Some of the court's recent decisions have made the role of dissent even more important. Polls have shown that confidence in the court is at its lowest rate ever, in part because some of the decisions are not supported by the general public, as shown by sociological studies, and in part because the decisions of the court are often made in the shadows. Continuing the practice of oral dissents is important. Both the public and aspiring lawyers need to see that the meaning of law is always being contested, and there is not one monolithic source for reason, values, or justification. Dissents are important, as Lonnie Guinier has noted, because they create salient moments of democratic accountability. These moments are badly needed in today's current political climate. Thank you.
Thank you, Christine. Just alert all of the participants that the easiest way to submit a question would be to submit it under the Q&A, and then I will address that to Christine directly. I will take the honor of the first question, Christine, if I might. I guess I'm curious how you would, looking from Chief Justice Roberts' perspective, he's obviously an institutionalist. I wonder if you would sort of predict how he would respond to the dissents from the bench, both from who are probably our two greatest sort of celebrity jurists. It's not an accident that you've chosen both Scalia and Ginsburg as your studies. And so I'm curious how you would respond to the critique that the oral dissents may in fact aggravate the politicization of the court, and that there is something perhaps to Brandeis's declaration that it's better to have it settled than to have it settled right. What would be your response to that?
So I'm a fan of opening up the process in a sense, and while I understand obviously stability is important, that that precedents are important, that there's the reliance aspect on precedent. So having something settled is hugely important so that people can conform that behavior to that settled law. But at the same time, when issues have not, when there's little consensus about issues in society, I think it does a disservice to say, well, this is what the rule is going to be, regardless of whether it's right, just because it's better to be settled. So
Sure.
I'd sort of push back on that. I'd say if society is coming to terms with what's appropriate, what is the best outcome, I think having settled precedent is kind of, tilting the scales too much to one side, if there's still ongoing dispute about that. So for Chief Justice Roberts, I don't know how he would think about this. So I was reading an article that the court has become the Kardashian court. They're sort of taken with their own self-importance right now, and are very much, see themselves as stars. And I think when you have a court comprised of people who see themselves all as stars, it's hard to be an institutionalist and kind of keep control of the court, because justices are going off and giving talks and I think not receiving the same level of adulation that Scalia and Ginsburg received, but still receiving a good deal of adulation. And so corralling the court and trying to move moderately and slowly, I think is very difficult. And I mean, you saw that in the Dobbs case, looking at Chief Justice Roberts' opinion is like, let's move slowly, let's take these incremental steps. And the rest of the court, just, you know, the majority of the court just disregarding that. So I think Justice Roberts probably would be comfortable with less dissent if the court were taking moderate steps. But I don't think the court is taking moderate steps. So I guess that would be interesting.
And then a quick follow-up, who would you identify as the natural heirs to the performative oral dissents of Scalia and Ginsburg? Obviously, we can identify some errors from their wing of the court, but are there current justices that seem to be as eager to use the oral dissent as an opportunity to express their jurisprudence?
So I have noticed that Justice Kagan has stepped up her dissents recently, and I think Justice Sotomayor would, and I think that in each of their own different ways, that Justice Ginsburg and Justice Scalia had really big personalities, and I think you need to have that in some ways to carry off that oral dissent. Like, you're doing that because you want people to pay attention. You're doing that because you're speaking to a particular audience. And so I think that that you need someone with a big personality to step up. And I'm not sure that I see necessarily any natural heirs on that level stepping up.
Judy, I see you had a hand up.
I did. I just did it the old-fashioned way.
That's all good.
Christine, again, thank you for the talk, and I really, really love the paper. So one of the things that you talked about a chunk of in the paper is the differences between the giving a dissent orally versus written dissents, and how the oral dissent, as you said, you're speaking to different audiences in a lot of ways. You started your survey, I think, with 2000, and then carried it until each of their deaths, 16 and 19. How do you think the audiences have changed in that time, and what do you see going forward? So one of the things that I'm constantly surprised by anytime any news, which is now entertainment, it's not news, is soundbite colors and all these things that, to me, maybe I was just unaware of it, and that was, the same kind of culture in 2000. But how do you think the audiences, whether you're talking about the Justice Ginsburg approach of trying to move society, legislatures, Congress, etc., or whether you're talking about Justice Scalia's approach, where he was trying to sort of create a record and, make him, for it to live on, sort of an infamy. How do you think, or do you think that audiences, the potential audiences, have changed or going to change in the future?
So obviously attention span, well, I think audiences are more partisan, right? So that audience only listen to people that reinforce their worldviews to some degree. Like, we don't seek out diversity of opinion. We want, to stay in our own comfort zone. So I think audiences have gotten more partisan. Attention spans have gotten shorter as well. But I do think on matters of huge social importance, I do think audiences will still engage. Like, even though we tend to be more partisan, that we listen to people who reinforce our worldviews, I do think that we want to understand on the big social issues where the other side is coming from. Although I think in some ways that's becoming harder and harder to do, because people are staking out more extreme positions for themselves. So I think also, again, it just, to me, goes back to, that you need a big personality to carry off the oral dissent to some degree, or you need a following to carry that off. And when I think about the personalities on the court, I'm not sure that right now anyone's really stepped up to assume that mantle on either side, either on the sort of originalist side or on the liberal side of the court. And I think it's like, I think Scalia took sort of pleasure in having his audience and being provocative, and Ginsburg in a kind of more toned down way did too. She liked being called notorious RBG. And I don't think you get that level of attention being paid to the court without those two big personalities there.
We have a few questions in the queue. The first one is from Glenn Butterton. Thank you for this fascinating, sophisticated talk. For those of us who have not read the article, what does the word performative mean in your title?
So I actually hate the title now and would change if I could. But too late, that ship's out. So to me, it sort of reading that dissent orally is very performative, in the sense the word performative meant so Justice Ginsburg, for example, would always don her special dissenting collars. So she had one of her particular white collars that she wore with her robes, that was the dissenting collar. So when she wore that, you knew that she was going to read a dissent that day. And so to me, that was a very performative act. It was, look at me, this event's going to happen. The audience knows it, I know it, you know, and I think obviously your dissents are going to be published. Like, you've written them, they're going to be published. They're going to be on Oye. So why would you feel the need to speak them? So to me, that act of speaking was a very kind of performative act. And I feel that's one of the areas of the paper that I didn't do a good job of kind of teasing out the difference between writing and speaking, to refer to what Judy was talking about earlier, that there's something more attention getting, that you want a response if you speak, right? You want people to hear you, and you do when you write as well. You want someone to read this, but I think the immediacy of the speaking situation and the kind of dramatic nature of it was what I was trying to get at, and by using the word performative.
All right, next question is from Linda Berger. Paper presentation. If you were a justice, how would you decide when to dissent orally? Assuming you don't want to dissent orally too often, when you were most outraged, ? When you think you might reach the public, or something else?
So I think it's a combination of the two, and I think that's a really important point. And again, thank you, Linda, for all your writing that I've always been inspired by. I'm a big fan of Linda's. So I think that obviously you don't want to do it too often, because it loses its, you know, the dramatic impact that it has if you do it routinely. So you've got to, I think, be speaking with outrage. You've got to be using it in cases where you're calling the other justices to account. You're basically saying, look, are you comfortable knowing, you know, this little old lady's going to lose her house, or that these, you know, in the Lily Ledbetter case, that these acts of pay discrimination will continue, kind of thing, because of your narrow reading of the law. So I think, yes, it's I think in cases, but also you're orally dissenting because you want people to hear you. You want people to respond. So I think both of those things. And so you've got to really choose wisely, like which is the most outrageous thing and what are people going to care about as well. Because I think in some ways the point of dissent is, to go back to Judy's earlier point, you're hoping, and I think Ruth Bader Ginsburg said this, you're hoping that someday your dissent will become the law.
All right, next question is from Kimberly Holst. Given the false notion that judges and justices can or should make decisions based on reason rather than from an emotionally informed perspective, do you think that oral dissents might be seen as less reasonable because they are delivered with more emotion and passion? ? And I know that the tone piece was only a small portion of the paper, but I wonder if you came across any other interesting points in your research on this idea.
So the tone piece is hard because there is not a lot of research out there on tone. And somebody, I think I cited in the paper, somebody who had done a study saying that Scalia is the most sarcastic justice because that person coded a lot of sense for tone. So I think that the tone is difficult. So Kim, that's a really interesting point about like the passion. Do you undermine your reason by sounding impassioned about something? And I would say, you know, you're not totally ditching reason, but you have to be impassioned in order to speak a dissent. You have to actually think that the court is wrong. And I don't think passion and reason are, you know, sort of strange bedfellows. I think they can work together, that through your passion, you're showing that the majority's reasoning is wrong, but you have reasons. It's not just an emotional response.
All right. Next question is from Mary Bowman. So many interesting aspects to the talk. One question about professional identity formation in students. How can we best address the fact that dissents are by definition, quote, not the law, you know, on the losing side of cases? Does that convey the message that in fact their perspectives are not the law? How can we minimize that risk potential harm?
Yeah, so I mean, obviously that's a hugely important point. And our students, like especially in the early stages, are not always adept at, you know, at remembering that dissents are not the law. But I do think maybe looking back at older dissents that have become the law, or dissents in cases that, you know, cases that we're now ashamed of, in a sense, that became the law, and thinking of Korematsu and those line of cases. I think it's important to say to students, okay, right now the law is what the majority says it is, but, you know, pointing them to examples where what was a dissent ultimately then became the law, I think is important too. But I mean, I am very mindful of, you don't want to pretend that a dissent is the law.
All right. I have one final question, because there seems to, and if there's any more in the queue, please, or any more questions, please submit them. Christine, there seems to be a tension in terms of Justice Scalia's sort of autonomous rule-based jurisprudence, and the need for him to use the oral dissents to sort of amplify that, because that is sort of, by definition, you're not trying to appeal to public in order to reinforce that. So is it fair to say that Justice Scalia more or less liked the sound of his own voice in those dissents, in sense, because by contrast, Justice Ginsburg, you know, because of her sort of responsive advocacy, sort of social justice themes, that sort of does invite the oral presentation from the bench in order to reach the audience. So it seems to me that there's a tension there. I understand Justice Ginsburg's her feeling and necessity to perform from the bench for her view. I'm less persuaded by the necessity of it for Justice Scalia. And I wonder if you have some thoughts about that tension.
Yeah, no, that's a really good question. Thanks, Andrew. So I do think that Justice Scalia did perform to a lesser extent, obviously, than Justice Ginsburg. I think that Justice Scalia performed dissents because he actually wrote this himself. He writes dissents for the academy and for law students in particular. And I think that's why he you know, used all the witticisms and the metaphors and the figures of speech that he did, was because he wanted to be remembered for those dissents, you know, through his turn of phrase and those devices that he was using. So I really think his sort of imagined audience, in a sense, would probably be future law students who would be reading this, or a professor in the class saying, oh, you know. And I think someone even wrote an article, read the Scalia dissent first, like before you even read the case, read the Scalia dissent, just because, I mean, he was a really gifted writer, and you know, people enjoyed reading those dissents, and he didn't pull his punches. So I think he was performing, but for a different audience. Like, he wasn't necessarily, I don't think, looking for change in the way that Ginsburg was, but definitely performing for an audience, in my view, anyway.
All right, I do believe with that, we are at the end of our program. As much as those participants can somehow express their applause and gratitude for this fine presentation by Professor Christine Venter, that would be wonderful. Tamara or Judy, any concluding remarks?
Just thank you again, Christine. This was just a spectacular talk. It's a fantastic paper. I really, really enjoyed it. It just gave us lots of good things to think about. So thank you so much.
Well, thank you so much for inviting me, and thank you to Tamara and to Andrew for hosting this. And also a quick shout out to my TA, Barrett Cole, who jumped on here and who's in London and who helped me research this paper. And so what she's like 5 hours ahead in London. Thank you, Barrett. I couldn't have done it without you. So thanks so much, everybody. And
all right. Hey, we look forward to seeing everyone for the 4th annual Judy Stinson Lecture next year in 2024. We're very proud of the esteemed colleagues that have participated so far, and we look forward to this lecture series into posterity. So thank you all. Have a wonderful day.
Bye. Thank you.